Good evening and welcome back to another episode of Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an update on the Citizenship Amendment Act. You must be hearing about this on all social media platforms, news channels, etc. The Citizenship Amendment Act or CAA was passed by the Parliament in December 2019. It amends the Citizenship Act of 1955 to provide a path to get Indian citizenship for certain religious minorities from Afghanistan, Bangladesh and Pakistan who entered India on or before 31st December 2014. The CAA specifically benefits Hindu, Sikh, Buddhist, Jain, Parsi and Christian immigrants from these countries. Critics argue that the law is discriminatory because it excludes Muslims and undermines the secular principles of the Indian Constitution. However, the implementation of the law was put on hold in view of the massive countrywide protests which took place against it back in 2020. Over 100 writ petitions have been filed in the Supreme Court challenging the constitutionality of the law. They were last listed before the court in October 2022. The Apex Court, while agreeing to hear the matter, had declined to stay the operation of the Act. The recent development is that last week the Centre notified rules for the Act, paving the way for implementation of the law as well as formation of committees at the state or union territory level to process the applications under the Act. Following this, applications seeking to stay the Act and the rules were filed. Today, a bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra heard the matter. Solicitor General Tushar Mehta sought time to respond to the hundreds of petitions and the applications. He also told the court that the centre would require 4 weeks' time to file a response. The court issued notice, granted 3 weeks' time and posted the matter to 9th April. When senior advocate Indira Jaising insisted that the court clarify in its order that any citizenship granted in the meantime will be subject to the outcome of the petitions, Chief Justice Chandrachud pointed out that the government had neither the infrastructure nor the committees processing citizenship applications in place. The discussion also touched upon the unique situation in Assam and the Northeast regarding exclusion of certain areas from CAA's operation. The court said that owing to the earlier order of detagging the Assam batch, those petitions would be segregated. Stay tuned with us as we update you regarding this issue. In another important update, the Supreme Court has ordered personal appearance of Patanjali's Managing Director Acharya Balkrishna and co-founder Baba Ramdev in the contempt case over misleading medical advertisements. The bench of Justices Hima Kohli and Ehsanuddin Amanullah was hearing the writ petition filed by the Indian Medical Association, which raised concerns over continuous spread of misinformation regarding allopathy and the modern system of medicine. It also asserted that Patanjali's misleading advertisements disparage allopathy and make false claims about curing certain diseases. As you already know, the court had previously issued a contempt notice to Patanjali Ayurved for continuing to publish misleading advertisements regarding medical cures despite the assurance given by its counsel that it would refrain from making such advertisements. Today, when the bench was informed that the reply to the contempt notice was not filed, it went on to pass an order seeking the personal appearance of Acharya Balkrishna. Further, the court not only issued contempt notice to Baba Ramdev but also directed for his personal appearance. Also, during the previous hearing, the court had criticized the union government for not acting on the advertisements under the Act, that is Drugs and Magic Remedies Objectionable Advertisements Act of 1954. The court had ordered the union to file a detailed affidavit outlining the steps taken. However, it was today informed that the affidavit was not on record as it was filed yesterday. The court questioned as to why the affidavit was filed only the day before and then granted the union one last chance to ensure that the affidavit was on record and copies provided to all relevant parties. The Supreme Court bench comprising Justice C.T. Ravi Kumar and Justice Rajesh Bindal has granted bail to Upendranath Dalai, the man against whom contempt proceedings are going on. Back in 2002, the Supreme Court had dismissed a PIL filed by him which sought to declare Satsang founder Shri Shri Thakur Anukul Chandra a Paramatma. The court had also imposed an exemplary cost of 1 lakh rupees. However, Dalai failed to deposit this cost. As a result, the present suo motu contempt case came to be initiated by the court last year. On the last hearing, he handed over a reply in court without filing it procedurally. The reply, instead of tendering an apology, contained additional contemptuous remarks. Despite being offered legal assistance by the court, the contemner insisted on defending by himself. The court has now added additional criminal contempt charges against him for making contemptuous statements in filing his email reply and another subsequent reply where he scandalized and lowered the authority of the court. However, he was granted bail. The court noted that though it was not satisfied with the manner in which the alleged contemner was responding to the notices and queries of the court, it considered, in the interest of justice, to enlarge him on bail subject to the terms and conditions to be imposed by the Chief Judicial Magistrate Balasore, Odisha. Also, the court directed the registry to refrain from accepting any new filings or appeals from the contemner except for those pertaining to the current case till the time the present matter is not decided. This matter will now be heard on 2nd April. Stay tuned. Coming to the next update, that is on the Delhi excise policy case. The Supreme Court today permitted withdrawal of the plea by Bharat Rashtriya Samiti leader and former Telangana Chief Minister's daughter, K. Kavita, challenging ED summons in relation to the case. The central agency is currently investigating Kavita's role in influencing the now scrapped liquor policy in the national capital and related bribery allegations. Last year, her writ petition was tagged with a 2018 plea filed by senior advocate Nalini Chidambaram, who approached the top court after the Madras High Court refused to quash the ED summons against her in the Shraddha Chit Fund scam case. This matter was adjourned on the last date, that is 15th March. On the same day, reports of Kavita's arrest by the Enforcement Directorate came in. The next day, a Delhi court remanded Kavita to ED custody till 23rd March. Kavita, who was produced before the court, claimed that the arrest was illegal and she would fight it in the court. The plea was today dismissed as withdrawn by a bench of Justices Bela M. Trivedi and Pankaj Mittal with liberty to pursue appropriate remedies in accordance with law. Also, Kavita has filed a separate writ petition in the Supreme Court yesterday challenging the arrest by the ED. Coming to another important update from the Supreme Court. A bench comprising Justices Suryakant and K.V. Vishwanathan today heard a special leave petition filed by Sharad Pawar Group challenging decision of the Election Commission dated 6th February to officially recognize Ajit Pawar Group as the real NCP and allotting the party symbol clock to them. On the previous day, after hearing the objections raised by Sharad Pawar Group, the court had asked the Ajit Pawar Group to refrain from using the name and pictures of Sharad Pawar in election posters. Today, the Ajit Pawar faction filed an undertaking agreeing to refrain from using the names and pictures of Sharad Pawar in campaign materials. Since there was no agreement on not using the clock symbol, the bench proceeded to hear the Sharad Pawar Group's arguments for interim stay on merits. After hearing the arguments, the court directed that the Ajit Pawar faction should make a public declaration notifying that the allocation of clock symbol is sub judice and the respondents shall be permitted to use the same subject to the final outcome of the proceedings. The court also directed that the man-blowing trumpet symbol will be reserved for NCP Sharad Pawar faction for the parliamentary and state assembly elections and that it shall not be allocated to any other political party independent candidate, and that the same shall not be used in any manner by the respondents, that is NCP Ajit Pawar faction, in the ensuing elections. The Bombay High Court has today sentenced former Mumbai Police Encounter Specialist Pradeep Sharma to life imprisonment while upholding the life imprisonment awarded to 13 others, including 12 police personnel in the case of fake encounter killing of Lakhan Bhaiya in the year 2006. Lakhan was allegedly the former aide of notorious gangster Chota Rajan. Justices Revati Moite Dere and Gauri Godse had reserved the appeals for judgment on 8th November last year, and Pradeep Sharma, who was acquitted earlier, was asked to surrender within 3 weeks. The court also lamented the gruesome death of sole eyewitness Anil Bheda days before his deposition in the year 2011. Calling it a shame and a travesty of justice that the prime witness lost his life but no one was booked to date, it hoped that Bheda's perpetrators would be prosecuted. Regarding Pradeep Sharma, who was the sole accused to be acquitted by the trial court, the High Court said that all circumstances were overlooked by the trial judge and the finding of acquittal was perverse and unsustainable by ignoring the excluding relevant material. And lastly, the Supreme Court today posted to July 2024 the pleas calling for reconsideration of the judgment in Vijay Madan Lal Chaudhary versus Union of India, which upheld constitutional validity of various provisions of Prevention of Money Laundering Act. Till such time, the special bench of Justices Sanjeev Khanna, M.M. Sundaresh and Bela M. Trivedi has permitted the appellants to file bail applications before appropriate forums, which shall be dealt with in accordance with law, uninfluenced by the fact that the present petitions or appeals are pending before the Supreme Court. If you remember, in November last year, a bench of Justices Sanjay Kishan Kaul, Sanjeev Khanna and Bela M. Trivedi, which was earlier hearing the instant pleas, was dissolved as the union government sought more time to prepare and Justice Kaul was set to retire in a month. Thus, a request was made to the Chief Justice to constitute another bench, and it led to replacement of Justice Kaul by Justice Sundaresh. Besides the instant pleas, there is also a review petition pending before the top court against the Vijay Madan Lal judgment, which is yet to be listed. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.